Progress. All right, good morning, everyone, and welcome to our webinar on the WA Workers' Compensation and Injury Management Act of 2023. We're now 4 months into its implementation and thought it'd be a great time to go through some of the key changes and some of our observations. If you have any questions along the way, pop them in the Q&A section below, and if we have time at the end, we'll run through them. If we do happen to run short of time, we'll do our best to answer them and get an answer to you down the line. So today I'm joined by Luke Westell, Team Leader of our Injury Management Department, and one of our Regional Directors and WA NEBA Broker of the Year, Chelsey Harris. Welcome to you both.
Thank you.
So as I mentioned, we're now 4 months into the new Act, following its implementation on the 1st of July. The new Act was completely rewritten from the previous version from 1981, with the intention of making things simpler and also to deliver on some key election promises from the WA Labor government. Now, before we get into great detail, what is workers' compensation insurance and why do you need it?
Sorry, Julian, are you moving the slides, mate?
They're just lagging
a little bit,
unfortunately. There we go. What is workers' comp insurance and why do you need it? So it's a legal requirement for anyone that employs workers, and it covers the cost of that worker's wages, medicals and other expenses that relate to that injury. Now, who's covered as a worker isn't always perfectly straightforward. The new legislation somewhat simplifies the situation with contractors, though, where essentially if somebody operates their own business and is engaged by you to do work that they would usually carry out within that business, then they may not be deemed a worker anymore. However, if that same person is engaged to do something outside of their usual operations, and I'd use the example of like a bricklayer. They usually do bricklaying work and then they're asked to do some handyman work to finish off a job. Then that's a situation where they may actually fall under the definition of a worker. There is an info sheet on contractors on the WorkCover WA website. And you can also ask your broker for further clarification on whether a contractor may be classified as a worker and what wages you need to declare when taking out your workers' comp insurance policy. I'll now hand over to Chelsey, who's going to discuss the impact to policy coverage and renewals. Thanks, Chelsey.
Thanks, Julian, and welcome everyone. So I'd like to cover off on a few changes to the new Act, which affects your workers' comp insurance as well as your obligations. So we're going to dive further into your obligations as an employer regarding record keeping and remuneration, as well as some policy inclusions and exclusions, namely working directors, industrial disease cover and employees residing overseas, as well as some changes with the insurers regarding premium rates and premium payments. Next slide, thanks, Julian. So as an employer, you're now required to keep current and accurate records for up to 7 years. These records must include for each policy period the number of employees insured under your workers' comp policy, the industry classification in which your workers' comp premium was determined, and the total remuneration paid. These records can be requested at any time by WorkCover WA for inspection. Next one, Julian. This one's a bit heavy, so stay with me, guys. So previously, remuneration was provided each year on one form. Under the new Act, you are now required to complete 2 separate declarations. The declaration of estimated remuneration is due prior to your renewal date or inception of the policy, and it's used to calculate your premium for the new policy period. The declaration of actual remuneration is required within 1 month after the renewal date of your policy, and it's a declaration of the total remuneration paid to your workers for the previous policy period. There are now penalties for not complying with these declarations or providing false or misleading information in the forms. An inspection or an audit of remuneration paid or payable may be conducted by the insurer or WorkCover WA to determine if the declarations are accurate. A fine of up to $10,000 in respect of each worker to whom the offence relates may be applicable. It's also important to note that WorkCover WA receives information from the ATO with respect to each employing legal entity with a workers' compensation policy. Next slide, Julian. So policy inclusions and exclusions. So WA Industrial Disease Workers' Compensation. So this cover is applicable for those entering or working on a mine site. Cover was previously provided by a separate policy issued through the Insurance Commission of WA, or ICWA. Under the new legislation, cover is automatically provided under the primary workers' compensation policy, which then also includes industrial disease common law cover. Therefore, the extension is no longer required. For working directors, in regards to working directors, there's been the option to cover a working director of a private or proprietary limited company. Under the new Act, cover can now also be provided for a working director of a public listed company. There is no change to the information required to nominate a working director, i.e. the name and remuneration of each working director is still required in order to provide cover. If a working director is not named and no remuneration is provided, there is no cover under the policy. For employees residing overseas, under the new Act, cover is available for a worker residing outside of Australia for up to 24 months. Under the old Act, the limitation for a worker residing overseas was 6 months. Next slide, Julian. So insurers. So standard industry or gazette rates are recommended premium rates set by WorkCover WA, and these are updated each year for each industry class. Insurers can then discount or load these rates on each individual policy. Previously, an insurer could not load a rate above 75% without an application to WorkCover WA for approval. Under the new Act, insurers can load the premium rates above 75% without WorkCover WA's approval and therefore charge the applicable premium. However, rates above 75% can be appealed, and an application to WorkCover WA to review the loading may be submitted within 1 month of receiving the insurer terms. In these cases, your broker will advise you of your rights to seek a review, and they will also manage the application process. In regards to premium payments, our credit terms are 30 days, and if payment is not received within this time frame, we are required to notify your insurer. If premiums remain unpaid after 90 days, an application can be made by the insurer or WorkCover WA to cancel the policy. So before I hand it back over to Julian and Luke, I'll just keep my insurance broker hat on for a minute longer and say that after today's session, if you do have any questions about your workers' comp policy and the changes to the legislation, please reach out to your broker. We have a lot of them online with us at the moment, and they are all up to speed with the changes in the Act and any impact to your current insurance. Thanks, Julian and Luke.
Chelsey. So Luke and I will now talk through a bit more of the injury management and claim focused areas. And in the interest of time, we've tried to boil it down to those 6 key areas. Employer restrictions, deferred liability claims, which used to be called pending claims, psychological exclusions, return to work, medical expenses, and disputes and settlements. The very short, very simplified version of the net result of the changes is that workers' comp claims are likely to, on the whole, cost a little bit more. So continuing to make health and safety and prevention should remain a priority because we know prevention is always better than cure. So let's delve into some of these changes. Across the board, WorkCover WA has increased the number of finable offences and the value of such fines. I think Chelsey mentioned one earlier. And they're big sums of money. They've been very vocal about compliance to all stakeholders, and we are seeing warnings and such issued to clients. So even prior to an injury occurring during the pre-employment screening of a worker, it's now prohibited to ask them whether they've had a previous workers' comp claim. I think the fine is about $5,000 if you're found in breach of that. Now, this isn't to say that you're restricted from asking about previous injuries, as this is really important or can be really important to assess a worker's suitability for a role, but specifically whether that injury was a claim is banned. Another employer restriction relates to the attending of medical appointments. Employers mustn't be present for the clinical examination of a worker, as well as treatment. Even if that worker has said, yeah, no, it's fine, come in. There is risk there that work cover can issue a fine. At first, it seems really restrictive and sort of against, as I say, the vast majority of employers wanting to do the right thing. The intention isn't to remove that opportunity to discuss the provision of suitable duties and a return to work plan with the doctor. So this aspect of it is still possible. It just needs to be conducted as a case conference after that clinical examination is completed. Another really important point to note, another obligation they're putting on employers is to make sure that claim is lodged within 7 calendar days of receiving it. And it's a $5,000 fine that's potentially applicable for breaching that. And as I say, I have seen a letter where a client was 1 day late and they're sort of issuing a warning. So work cover certainly seems to be a cat on a hot tin roof with some of these things. Luke, I might hand over to you to cover the next couple of topics.
Yes, thank you, and hello everyone. So deferred liability is the next one, and it probably comes with a bit of a preface. This is obviously a new act. It's not an amendment to the old act. It's not a change. It's not patchwork. It's brand new. And so where we talk about deferred liability claims, for example, there's a shift in the language that's being used. It's modernised language as part of the new act. So whilst we were familiar with a bunch of old terms, some of those have transitioned to new language, and with that some change in meaning and the way that it operates. And in this case, it's the difference between penned and deferred. So historically, an insurer would need to accept, deny, or pend liability within 14 days. Now, if the insurer can't make up their mind to accept or deny, they need to defer the decision. Similarly to the old act, if they don't accept, decline, or defer now within 14 days, liability for the claim is deemed to be accepted. With the new scheme, there's a clear distinction between just a mere compensation claim and an incapacity claim. An incapacity claim being a claim for income compensation, which was previously known as weekly payments. This in itself is important to note because in the 1981 Act, there were no timeframes in place or regulated notices for accepting, denying, or pending where there was no incapacity or weekly payments being claimed. These were just medical expenses only claims. And look, arguably, if you were to make a payment on a medical expenses only claim, that wouldn't prejudice your position on liability if there was incapacity later on down the track and you needed to make a decision with respect to liability and provide that regulated notice. The new Act, though, requires that a liability notice on a compensation claim, so without the incapacity, and if there is then incapacity as well as compensation being claimed, then that needs to be stated on the notice. So kind of in a way, what we're saying is that the old Act was structured around this claim for weekly payments, and that medical expenses only claims are a bit of an afterthought. The legislator almost said, right, every claim is going to need incapacity, and there will be some people that just want to claim a visit to the doctor. The 2023 Act puts medical expenses front and centre, and then adds incapacity as a limb to that. So we've sort of seen it's a change in structure, it's a change of way of looking at what makes up a claim. It means that we then look at things like provisional payments. So this is a concept that's new in the 2023 Act, not necessarily new to workers' compensation nationwide, but certainly new to the WA scheme. And important to understand is we've kind of gotten used to the term payments as referring to weekly payments of compensation, whereas provisional payments and that terminology encompasses all compensation. So it's not just incapacity payments, it's medical and other expenses as well. So, and when I'm talking about provisional payments, they're an entitlement a worker has if they have a deferred claim after 28 days from which the insurer received the claim. So insurer receives the claim, they defer it within the 14 days, and then 28 days after they've received it, provisional payments kick in if a decision on liability hasn't been made. So if it hasn't been accepted or denied, provisional payments kick in. And provisional payments are any medical or health expenses, as well as income compensation that the worker would have been entitled to if their claim had been accepted. So where we're talking about income compensation, if there was an incapacity, medical certificate, medical report that suggests this injury caused an incapacity, and that was 5 weeks before, that was 5 months before, or even longer before, payments start from that date and continue ongoing throughout the provisional payment period, unless there's evidence, obviously, to suggest that incapacity no longer continues. Medical and health expenses are included, and there is a limit on the amount that can be paid for medical and health expenses when it comes to provisional payments. That's 5% of the general maximum for that bucket, and we'll talk to sort of limits and whatnot shortly. But important to note in terms of understanding that whilst there is limits, provisional payments aren't recoverable. So we go through the process of investigating a claim. It's been deferred. This person's in receipt of income compensation. We've paid a whole bunch of medical expenses. And then ultimately, the inquiries are concluded and liability for the claim is denied. What they've received or what's been paid on their behalf isn't recoverable against the cost of the claim. There is the exception, obviously, if there's if the person is convicted of fraud, then there's an opportunity to recover those payments, but that's a very rare case. So we obviously operate on the basis that they're unrecoverable. The old scheme saw that in terms of pending claims that after 10 days of being pended, they were deemed in dispute. So it effectively said, insurer, you've got 14 days to make a call on this. If you can't make a call and you pend it, make your inquiries, but after 10 days, it's just a denied claim, and the worker can do what they want in terms of trying to progress that, whether it's go down the dispute path or whatever the case may be, but it's denied after 10 days. And that was the extent of any timeframes. So there's still claims from the 90s, the early 2000s, and more recent that were pended and that have had no formal liability decision made on them because they're technically deemed in dispute. The legislator didn't like that, WorkCover didn't like that, so as part of the new scheme, they've added some timeframes. That timeframe is 120 days. If it's deferred for 120 days when the insurer receives the claim, if the insurer hasn't made a decision on liability, it's deemed accepted. They've flipped it. They've said that if the insurer is not going to do anything about it, the worker gets everything that they're claiming. So it forces the insurer to make a decision, it forces them to conduct their investigations, and it forces them to act and do so relatively quickly. So in terms of what we're seeing with some of these changes, those timeframes have, in terms of provisional payments as well as the deemed acceptance, it's injected some urgency in terms of the investigation process. I think for the most part, it's working well. Factual investigators have, certainly a number of providers have changed the way that they operate, changed the way they report through to the insurers. It's a lot more collaborative. It's a lot quicker. They're making sure that statements are being obtained as soon as possible, and getting that information to the insurer to make decisions instead of waiting to collect it all at the end a month or two later and giving it to them in a bundle. We have seen a reduction in the number of disputes proceeding to conciliation arbitration service. We're anticipating, and certainly from industry feedback, that the statistical data that WorkCover release in due course will reflect that scheme-wide as well. Claims costs have remained relatively steady on deferred claims as compared to pended claims. We see that that's happened more so because the concept of without prejudice payments on pended claims was fairly commonplace. So we recognise, certainly in the last sort of, I would say, 10 years or so, there's recognition that if we help somebody recover from their injury, then if there's a decision that is, for example, to accept the claim, that the overall claims cost will be low. And knowing that the vast majority of claims that were pended ended up being accepted, it made good commercial sense to try and mitigate that loss by using without prejudice payments. And the concept of provisional payments, and similar to what's happening in some of the other schemes across the country, we see the person's able to get the treatment, and it's kind of just it's a forced without prejudice payments situation. So in terms of those claims costs, it's not having a materially negative impact. But positively, insurers have reported, anecdotally from the data, suggests that return to work rates on deferred claims have improved against, or when compared with pending claims. An important measure for obvious reasons, but it does mean that where we had pending claims 3, 4, 5 months, no return to work, then liability is accepted or it's deemed compensable. Suddenly you've got somebody who's been out of the workplace for that period of time, and they haven't attempted to return to work, and acute injuries turning chronic, and it's much harder then to manage the claim long term. So with improved return to work rates, we've got people in receipt of provisional payments, and they're participating in return to work programs. It means that if the decision to accept liability does eventuate, then the duration and cost of the claim is reduced. You've got somebody who's returning to work, and we can start to manage the claim accordingly. Jules, I'll get you to move on to the next slide for me, please, because deferred claims and psychological exclusions kind of run into one of themselves. The stress claims have historically had high rates of liability being pended or deferred, and proportionally they're disputed more than physical injury claims. They're making up an increasing percentage of matters being dealt with in the conciliation and arbitration service, and none of that probably comes as a surprise to most of you on here today. Look, nationwide, each scheme deals with stress claims or mental health claims or psychological claims differently. The WA scheme now aligns a little bit better with some of the more common principles. There's still exclusions, and those exclusions have been broadened. And the term or phrase administrative action is now specifically defined. And so whilst we've got the same exclusions that we had historically in terms of transfer, demotion, these kinds of actions, administrative action now also includes an appraisal of the worker's performance, suspension action, and disciplinary action. Now, the scheme did previously include discipline as an exclusion. The But this just led to disputes, some successful, some not, as to whether the process leading to discipline, such as the conversations or meetings to do with the worker's performance, formed part of the term discipline or not. Now that we've the concept now being in line with the other schemes, disciplinary action includes those steps leading up to the actual discipline taking place. Important to note, the concept that whatever action is being taken by an employer mustn't be unreasonable and harsh remains in place. How this generally plays out is where company policy isn't followed, usually an arbitrator, or should I say, or if an arbitrator considers that the administrative action that was taken ought not to have been conducted or conducted in the manner that it was, then the worker can still succeed on their claim. So naturally, we recommend that where administrative action is being taken, follow your internal policies, make sure everything's well documented, and know that with that documentation process occurring, if a claim does eventuate, we are looking to rely on it as an exclusion to decline the claim. Having that documentation ready, having those policies ready and available for the factual investigator can help reduce the amount of time it takes to investigate that claim. That then leads the insurer to being able to make the decision a lot quicker and reduces your exposure to provisional payments before the claim's declined. On to the next one, Jules.
Luke. The requirement to have an injury management system and return to work plan in place was in the previous Act and remains so in the new one. One of the key changes, though, is that return to work plans now need to be on a prescribed WorkCover WA form. This comes with it some positives and some negatives. Positively, the return to work plan no longer requires a GP to physically sign it off, so long as it's in line with the restrictions that GP's provided on the MedCert. However, a big drawback is that there's little flexibility to modify the form, and it doesn't provide that progression of duties, which can sort of help set up in a worker's mind how they ought to progress. Some would suggest an appendix outlining the likely progression can still be completed, but as I say, there's no modification to the form generally permitted. If you as a business don't have capacity to complete a return to work plan, we can assist in having a vocational rehab provider appointed to the claim that can help identify those suitable duties that fit in with the GP's recommendations. Once a worker's returned to their full pre-injury duties, it's best practice to confirm with us and the insurer, because there can be a bit of a lag between certification and their actual return to work. And there are ramifications to the worker's entitlement to income compensation when this occurs. Another one of the big changes from a dollars and cents perspective is with regards to medical entitlements. So the amount a worker can access has doubled to, I think it's about 158,000 now. And that'll get indexed annually, and there are other ways to further extend that. But perhaps just as, if not more significantly, which will is this category for miscellaneous expenses, which medical transport and prosthetics fall under. So these can be really significant costs. Things like Royal Flying Doctor Service. I'd use the example of a worker that's been significantly injured out on in rural Western Australia, and they need to get flown back into Perth. That Royal Flying Doctors Service bill can be $30,000. Now, under the old Act, that would be almost half of their entitlement shoot up. If they're then in hospital for a week, by the time they step out of hospital, they've just about used their old medical entitlement. So it's a bit of a double effect here that those funds no longer count towards that medical expense, and that medical expense has been doubled. So on the face of it, I think it's not a terrible thing. That it was relatively rare that you'd see workers exhaust their medical entitlements, and a lot of the time it was with those contributing factors. So where it is a change that allows workers to get the treatment that they need, and those ones that have been significantly injured. Oh, back to you, Luke, for disputes.
Back to me. So in terms of disputes, they continue to be heard through the Conciliation Arbitration Service. There's no change in that respect. The scheme, or the dispute scheme, is two-tiered. Again, no changes to the previous scheme. There have been some changes to the rules, the conciliation rules and the arbitration rules. Nothing material that we'd need to go through for the purposes of today. The general premise on how disputes are to be heard and determined remains exactly the same. So it's either, when it comes to disputes, it's either resolved during an informal conciliation phase, that first tier, or everybody sits around a boardroom table and has a bit of a chat about things, and the conciliation officer tries to mediate, and we either get a resolution or we don't. And if we don't get a resolution during the conciliation phase, it moves to the second tier, or the arbitration phase. This is the more formal setting. Hearings are recorded, and ultimately the concept is it leads to an arbitration hearing where witnesses are called, evidence is given, and the arbitrator makes their ruling as to whether the applicant is successful or not. So the first item there, legal scale costs arbitration. The way that costs are worked within the dispute scheme is that each tier, each phase has separate milestones within it, and depending on where it gets to within which milestone is achieved, the lawyers can claim up to a maximum amount of their costs for doing the work that's involved. Unless a dispute is heard, determined in favour of the employer pays the workers' costs. Obviously, it's covered through the workers' comp claim, but those costs are reflected against the claim at the end of the day. This is known as the scale of costs, and there were changes to the scale of costs as part of the new Act coming into play. The conciliation items have remained the same. There's still the same amount of hours that each milestone represents, or that can be claimed against each milestone. But there has been changes in terms of the maximum hours for the arbitration phase. Dollar figures wise, what this means, whilst it will naturally vary from case to case, complexity, duration, those sorts of things, the legal costs payable, so the workers' legal costs that are payable for matters that settled during the arbitration phase have gone from roughly a $15,000 to $20,000 mark to around the $30,000 to $40,000 mark. It's effectively doubled. And it probably wouldn't surprise you to learn that plaintiff lawyers are acutely aware of the fact that it has doubled and they can claim more in terms of costs. What we're seeing is that as a result, disputes are taking longer before we're getting outcomes. Settlements are not as forthcoming, certainly not during the conciliation phase, and certainly not on complex claims like stress claims, because if it's moved into the arbitration phase, more work can be done on it, more costs can be claimed. It's meaning that matters that were previously resolved during the conciliation phase are now moving into the arbitration phase, and that puts a strain on the arbitration service and the resources that it's got in order to deal with these matters. More matters, more hearings. They've got limited resources so the hearings then start to get pushed out. So where we'd have a directions hearing, which is sort of a hearing that's administrative in nature, it just decided to program for the main hearing, the arbitration, where we might have that happening in 3 or 4 weeks' time, it's extended out by another couple of weeks. Where arbitrations then that would go for, say, 2 or 3 days, we might be able to get a hearing within a couple of months, add an extra few months on top of that. Arbitrators are then involved in more matters, so delivering their decisions takes longer. Don't be surprised if it would take 6 to 12 months for a decision to be handed down. And all that then, it creates, for an injured worker, it creates potentially a financial burden. They're waiting for their claim to be heard and determined. They're not working. They're not receiving an income, or the income they're receiving is from Centrelink, and it's nowhere near what they were earning previously. And that creates this financial anxiety, financial worries, psychological issues, stress, and even for a physical injury, that will delay their recovery. So it doesn't bode well for their recovery from the injury that maybe is covered or maybe isn't. But ultimately, if we're then looking to try and settle it and we don't want to take it to a hearing, that's going to impact the claim. That's going to impact the amount that we're negotiating for. And certainly then if there's an adverse decision and the worker gets up on their claim, then it will have financial implications for it. And the delays on the other side don't bode well for us if we're lodging applications to stop somebody's income compensation. We're waiting longer. They're in receipt of payments, and the chance of recovering that simply because the scheme had limited resources is remote at best. So noting that that sort of, I suppose, disputes, settlements is another key element, and there's been a change in the settlement process. So historically, we weren't able to resolve a claim within the first 6 months, or redeem a claim, I should say. Somebody needed to be in receipt of weekly payments for at least 6 months. That provision is now gone. We were also able to resolve common law claims or potential common law claims and workers' comp claims by way of what was known as a 92F deed. And in those deeds, we could include things such as named principals. We could include privacy and confidentiality clauses. From time to time, it did also include matters unrelated to workers' comp, such as employee benefits being paid out, termination of employment, those sorts of things. That's gone. We can no longer do that, and we can no longer settle a common law claim unless the worker has the prerequisite permanent impairment and they've elected to pursue for damages. This change in process and the change in this change in process has led to a change in the settlement forms and documents being used, and it's taken quite some time for parties on both sides to appreciate the differences in how the regulator intends to interpret those differences. Consequently, settlements are taking longer to be registered. We're seeing anywhere up to a couple of months from the date that it's initially filed with the regulator, in order for that to be finalised, so the insurer can make the payment to the injured worker and actually close out the claim. That will likely in time reduce, but right now it is something that's impacting on settlement negotiations at times. And dealing with as I said, things like principles or privacy confidentiality, that's very much now a case-by-case basis as to how best we deal with that. And it's something that will, certainly in terms of the injury management team, and we're supporting you and talking you through that process. We'll discuss what those options are and provide our thoughts. Publishing of arbitration decisions is, I think, a potentially significant change with the new Act. So historically, or in the old scheme, appeals were published, and from 2011 onwards, those appeals were heard in the district court. So anybody searching through the district court judgments were able to read through and see what was happening. The 2023 Act, though, enables an arbitrator to publish their decisions. This, I think, is an element we need to think about where a matter is proceeding to an arbitration hearing. An adverse decision might cause reputational damage to the losing party, and both parties will generally call witnesses to give evidence, give their thoughts, and arbitrators will often be asked to comment on the credibility of those witnesses. Where decisions are being published, witnesses have given evidence, and the arbitrator has gone through and in detail about that witness's evidence and made some adverse findings that could impact those witnesses, and so ultimately may impact whether somebody is willing to provide that evidence in support or defence of an application. I think that's it from me on disputes and settlements, Joe.
Consent authority.
And it's me on consent authority. Wonderful. Consent authority. Whilst not a change in the Act, soon after the new Act came in force, the regulator issued a bulletin to effectively state that where there is no written informed consent from an injured worker for an insurer to provide information to an insurance broker, the insurer ought not to be providing that information. Yeah. What this doesn't mean is that that the insurer is prevented from speaking to an employer, not by any stretch. It doesn't mean that an employer is prevented from speaking with their insurance broker, and it doesn't mean that an insurance broker can have a one-way conversation with the insurer. We can deliver information as anybody can do. But what it has meant is insurers are reluctant to release the same level of information directly to an insurance broker. So what we are asking, and you may have received some correspondence from us 1 or 2 months ago about all of this, is that where a person suffers an injury, they're lodging a claim, that they complete the standardised insurance broker consent authority. It's a 3-page document. All 3 pages do need to be completed. The first page is an initial to acknowledge that the worker has read it. The second page is information about the claim, such as nature of injury, who the employer is, who the insurance broker is, so in this case EBM. And then the third page is the worker's autograph to say that they provide that consent. If we don't have it, it doesn't stop us from being able to assist. But what it does do is it makes it a little bit more challenging for everybody involved and can cause some delays. So our preference is very much to have that consent so that we can continue to provide our service in the same way that we have done historically. Thanks, Joe.
Beautiful. Thanks, Luke. Now, it's always good to put a face to a name. So here is the EBM injury management team. All members have significant experience in assisting with workers' comp claims and are always happy to take your calls on any queries that you might have. In addition to any ad hoc queries, in the event of a claim, our team are here to support your business in advocating for you and to ensure effective strategies are implemented to optimise claim outcomes, as well as to represent you at any meeting, conference, hearing, where appropriate and able. I guess it sort of feeds into the consent authority to some extent. If we're able to get that signed, then that certainly frees up our availability to be able to help. We're also able to provide support and education to your personnel regarding different stakeholders' obligations under the Act. In addition to this, we've got a network of service providers within the workers' comp scheme that have proven outcomes that we can recommend to engage on your claims. Now, while we're talking about providers and networks, our risk solutions network includes, but also extends beyond workplace injury risk. They consist of specialist providers across 8 pillars of support. giving EBM customers access to their expertise, training, and shared resources at pretty well discounted rates. For more information on the RSN, including who our partners are, get in touch with your broker. Yeah. So, to wrap up today's session, we generally recommend employers continue to review and revise their worksite health and safety policies and procedures to make sure they're keeping up with legislative requirements and with their business's needs, as well as to foster a positive culture around safety, injury, and return to work. Should an injury occur, again, we'd ask that you provide the consent authority to your injured worker along with the claim form to maximise the chances of their full engagement. As always, though, the EBM broking and injury management teams are here to support you in managing your workplace risk. Now let's get on to some questions.
Julian, we've got one question in the chat from Glenn. Good morning, Glenn. Glenn's question is, who pays provisional payments if the claim is denied?
Yeah, no, that's a good question. And the provisional payments act the same as ordinary compensation payments or income compensation payments. So for income compensation payments, that's payable by the employer, reimbursed by the insurer. For the medical and other expenses, the insurer will pay those directly. But ultimately, they will be reflected against the cost of the claim.
Thanks, Luke. Hopefully, Glenn, that answered your question. If anyone else has got any questions, they can pop them into the chat. Or I think as well, you're just going to run through the great app that you've got there, Julian.
Yeah. So we've got several resources available to you all through this QR code link. There's our WA Guide for Business. We've done a couple of podcasts with regards to the legislation. There's also the EBM insurance market summary from a couple of months ago. Is there any other questions coming through?
No, that's it. I think we must have covered off on everything well.
Yeah, look, it's one of those things. I think we've scratched the surface, but there's always plenty more that we can go into if you do think of anything after today. But I just want to reiterate, thank you all for your time today. It's been fantastic to connect with so many of you. And as I say, feel free to reach out if you do think of anything else that comes up along the way, whether that's to myself, Luke, your injury management account manager, or someone in your broking team.
I think we've just had one more quick question from Hunter. Do you think that these changes will have a run-on effect with premium prices?
Yeah, I mean, look, WorkCover's been pretty vocal in that they feel that it's been baked into premium rates for the last year or two. But I think time will tell. There's been probably some of the challenges that brokers have faced with regards to assisting our clients may well have a little bit of claim leakage impact. But I think, yeah, we know claims are going to cost more. So those clients, those employers that have more claims are likely to end up paying more for their premiums.
And Sung, a question from you. You missed some of the parts. Can you send us a recording of this? Yes, we have recorded today's session. So we will happily get your broker to send you a copy of that after the end of the webinar. Okay. We finished nice and early there, guys. Well done. So if there's no further questions, again, please reach out to your broker or the injury management team if you've got any questions. But we appreciate everyone joining us today. Thank you. Yes. Julian, have you got anything to add, or Luke?
Good from me.
Nothing further from me. Thank you, everybody.
Excellent.
Cheers, everyone.
Thank you. See you.